Good afternoon. Thank you for joining us. I am Sarah Wood, Executive Director at PMBA. I have a few housekeeping notes. You'll notice that when you signed on, you are in listen-only mode, but we do encourage participation. You should see on your screen a white panel with an area for questions and chat. As we are going along, if you have a question, please type it in that box. I will be passing questions to the speakers throughout the session, and we will pause occasionally to provide responses. So with that, let me introduce you to today's speakers. Colleen Wasserman is the National Co-Chair of the Jury Trial and Litigation Practice Group at Littler Mendelsohn. Colleen has devoted her entire career since 1987 to representing employers of all sizes and in all industries with regard to their labor and employment law needs. In addition to being an accomplished trial attorney, Colleen litigates single and multiple plaintiff cases as well as class actions before all state and federal courts in California. Colleen is often brought in to handle difficult cases and consult on trial-related matters and strategies. Colleen also provides advice and counsel and conducts group and individual training on important employment issues such as harassment and discrimination in the workplace. Colleen is also a frequent speaker and writer on employment law matters. David S. Mayaz advises and defends companies, executives, and management in all facets of employment law, ranging from compliance with state and federal statutes to internal investigations and administrative agency complaints through pre-litigation negotiations, trial, and appeal. David defends clients and against claims involving harassment, discrimination, retaliation, unpaid wages, and misclassification of exempt employees and independent contractors, as well as wrongful termination. In addition to his litigation practice, David frequently advises clients regarding compliance with federal, California, and local employment law, including companies and management with preparing and dealing with arbitration agreements, employee handbooks, medical leave qualifications and requirements, terminations of employment, and workforce restructuring. So at this point, I would like to turn the program over to David and Helene.
Thank you. Me too. Two very little words that have been now put together and have a hashtag in front of them. Not in recent history have two such little words had so much meaning and have been so impactful upon our society as well as upon organizations and businesses. You know, there's really nothing new here. I mean, the issues regarding harassment in the workplace have been going on for decades. It's been against the law to sexually harass or harass on any basis for that matter in the workplace for years and years. And even when it wasn't against the law, it's still not appropriate, never has been, never will be. But with this resurgence of awareness, it's making it important for employers and businesses to become more aware of what is going on in their workplaces. And in many respects to refresh or reboot their existing policies and practices. So with my colleague David Mayaz here today, we're going to talk to you and give you some ideas and some suggestions about how to address these issues in the workplace and how to protect your employees as well as your organization in this Me Too era. So we're going to go through various topics, and as you were told, we're going to take questions as we go along. A question may be posed to us that we may say we're going to get to, so don't feel offended if we don't answer your question right when you ask it, but we're going to be addressing these issues as we go along, and there'll be time at the end for questions. So first thing we're going to talk about are policies. And you know, it's that time of the year. At the beginning of the year, it's not uncommon for businesses to decide to look at their employee handbooks, their policies, and see what needs to be brushed up a little bit, what needs to be modified. So we're going to be talking about those kinds of policies. Then we're going to talk about complaint mechanisms. And it's important to make sure that businesses have in place and promulgated complaint mechanisms that will allow their employees to know exactly how to complain if there's something that goes wrong. And I'm hoping that I actually may have a couple of ideas and suggestions for some complaint mechanisms that you may not have thought about. So we'll talk about those. We're also then going to talk about, now that you've got policies and complaint mechanisms, what happens when an employee uses them? What happens when an employee actually complains? And we're going to talk about what to do with complaints. We're going to talk about the importance of an investigation and what that investigation should entail. And who should conduct that investigation, because it's really not the same in every circumstance. There are different reasons that different people should conduct investigations. And we'll talk you through some of those issues as well. Once you conduct the investigation and get the results, we're going to talk about what to do next. how to react, how to respond, and how to use the results of your investigation. And then we're going to talk about training, which is really where it all begins. How to train your workforce, what to train your workforce on to help prevent these types of claims from happening in the first place. So let's get started. So David, you know, what is that time of year? I've gotten a number of calls, and I'm sure you have as well, all about, is it time to review my handbook and what kind of policies that I should have in there? What are you advising those clients about, specifically with regard to the policies implicated by the Me Too movement?
So that's a good point, Helene. In regards to company policies, I do see that at the beginning of the year, a lot of companies do want to see if any new laws have been passed. And if so, what types of policies they need to enact in order to comply with those laws. So in terms of company policies, I think the first question is, why do we even need policies? With some policies, you are required by law to have. And not only are you required by law to have them in your handbook, you're also required by law to post them in the workplace. And you're also, with certain policies, required to hand them out to employees and get a written acknowledgement from them. So at the outset, it's very important to understand what's required in your particular jurisdiction. Employment laws obviously can be federal in scope, but they can also be state-specific in scope and oftentimes are. So requirements can vary from state to state, and it's important that you understand what policies you absolutely have to have in place. But if we move beyond that, because a lot of times the laws set a floor and not a ceiling, how do you know what additional policies to have in place? I think it's important to keep in mind that the policies that you have will set company culture, they will set the tone, and most importantly, it's a very surefire way to both have it memorialized and to disseminate it to your employees on a consistent basis. And so even though you may have turnover at the company, you're going to have consistent policies and you're going to have consistent application of those policies. So in terms of the very basic policies you're going to want to have, at the outset, you're going to want to have an equal employment opportunity policy. That's what we call an EEO policy. I think it's so ubiquitous these days that it's just an assumption that everybody's going to have that, and it should be, but it's still important to have it in writing. And that basically provides that everybody at the workplace has an equal opportunity to succeed. And that factors that are unrelated to job performance, unrelated to the workplace, are not going to be considered as part of the hiring process, discipline process, and separation process. So with an EEO policy in place, you're indicating what the employer is going to use as criteria to evaluate employees. Similarly, you're going to want to have policies in place as to what employees can and can't do amongst each other. And so in that regard, you're definitely going to want an anti-harassment policy. An anti-harassment policy needs to be properly drafted because you want it to be inclusive enough that it has all forms of harassment, and that will include sexual harassment. That'll include bullying at times. What you want to be mindful of, however, is that you don't go too far with your policies, and so that it doesn't restrict lawful conduct or employees' ability to communicate amongst themselves. So having a properly tailored anti-harassment policy is very important. Part and parcel of that, then, is to also have an anti-retaliation policy. Because to the extent that you have an equal employment policy and you have an anti-harassment policy, you want to be able to have folks raise issues without the fear of harassment. You also want folks to be able to raise these issues without the appearance of harassment. And for example, without getting too ahead in the presentation, you don't want to have a situation where anybody that complains is then treated unfavorably out of course. And so you want to make sure that it's clear if somebody raises an issue, they're not going to be retaliated against. Retaliation will not be condoned. And that if you suspect that that's happening, that you can raise that issue as well. And so by having a comprehensive set of policies in place, you're going to set the ground rules. You're going to have the roadmap of where you need to go. All of these policies, at times, you'll have some policies that are posted, but I think it's very good advice and a best practice to have all of these policies embodied in the employee handbook. And the employee handbook, again, as Helene alluded to at the outset, we get calls at the beginning of the year. It's not a static document. You don't create it once and it's in place for the life of the company. You need to revisit it. You need to make sure all categories are included in it. And you want to make sure that it's compliant with current developments in the law, which there are many.
You know, what's interesting is I actually just heard about two major corporations. When you talk about policies and making sure you don't have policies that preclude people from engaging in lawful conduct, I just heard about two major companies who shall remain nameless, who have recently implemented these dating policies. And I think the policy goes that if you are entitled to ask a coworker out on one date, and if that coworker says no, then you are forbidden from asking that coworker ever out again. Now, you know, we live in a society, we spend more time with the people that we work with, generally speaking, than with anybody else in our lives, which is unfortunately true, but it really is true, or at least our waking hours. So people do meet at work and people do date at work. But for companies to actually go so far in reaction to the Me Too movement, to actually create a policy that says you can only ask somebody out once, that might be going a little far and be a little reactionary to the Me Too movement. But it's perfectly appropriate for companies to have policies in place that govern how people interact with each other. Now,
and this raises a good point, Helene, and I think everybody should be mindful when we're discussing that the laws a lot of times set the floor and not the ceiling. This would be a prime example of that, meaning a company, after deciding what may work or may not work for them, they may decide to implement this type of policy. It's not legally required, but an employer can be within its rights to do so. But again, you don't want to overstep and you don't want to violate the law in an overzealous attempt to chill bad conduct in the workplace.
Right. Now, one of the other policies, and another thing that you need to think about, are complaint mechanisms. A very important policy is an open door policy. And different companies call it different things, but as long as you have some kind of an open door policy, that's vital, especially now in this Me Too era. Have it in your policy manual, have it posted on your bulletin boards, have it wherever you could possibly put it so that people know that they can complain. But the question becomes, who do you complain to and how to complain? So most open door policies identify what those places are. You can complain to your manager. And then if you don't feel comfortable complaining to your manager, excuse me, you can complain to the next level manager or any manager within the organization. Because keep in mind, if any manager within your organization becomes aware of inappropriate conduct, steps have to be taken, and we'll talk about those steps in a minute. But what are some other ways, other than simply having an open door policy that says you can complain to your manager, should you have? Well, obviously, employees need to be aware of where human resources is. And by where, I don't necessarily mean the physical location, although that's important too, but knowing how to complain to human resources. To whom in human resources to complain? How to complain? Do you have to do it in person? Can you do it in writing? Can you send an email? All of the different ways of communicating with human resources are vital to an effective open door type policy. Most companies nowadays, and those that didn't have these kinds of hotlines set up prior to Me Too are now setting them up, are these 800 numbers. They're global compliance type hotlines, local compliance hotlines, 800 numbers, where people can complain sometimes outside of the organization. Sometimes it's difficult for somebody to complain within the organization. They don't feel comfortable complaining to their manager or their manager's manager. They don't feel comfortable going and reaching out to somebody who may know the people that were involved. Sometimes it's a lot easier to call an anonymous 800 number that takes you to some other source that allows you the ability to complain. Most companies are setting those up right now. So these are all different ways to set up complaint reporting mechanisms. I have a couple of clients who've come up with some interesting and creative ways of approaching the situation. One client, for example, is in the hospitality industry and has a point of sale system that all employees are required to use this computer system to be able to, at the point of sale, check in and out every day. And at the end of the day, they have to log out of the system to be able to get paid, to reflect their hours, to reflect what time they came in and what time they came out. And what this company has done is, at the end of the day, when the employee logs out for the last time, they're asked a series of questions. And one of the questions they're asked is, have I been harassed? Have you been harassed today? If so, click yes. Or they're asked, have you been subjected to inappropriate treatment today? And if they click yes, that will immediately go to human resources, and they will then be aware of the situation and be aware to be able to address the situation with the employee. So that doesn't require any action by the employee other than clocking out for the day, which is something that they do on a regular basis. I've got another client who is in a different industry where all of their employees use a computer. And every day that they start their workday, they are required to log on to their computer. And when they log on to their computer, they've got a bunch of information that they need to know for the day. And also the home page that they log on to every day is, I'll call it an SOS button. And what it is basically, it says, if you have been subjected to inappropriate treatment, or if you've been subjected to harassment in the workplace, click here. And if they click there, that will immediately get them to the next page, which is a human resources page. And it will tell them exactly who to talk to. They'll get a response. That's how they will initiate the interaction. I mean, these kinds of interesting and creative ways do a couple of different things. First of all, it's yet more avenues, yet more ways for individuals to be able to reach out to the company if they believe that they've been subjected to inappropriate treatment. These are like as easy as they come. It really takes no volitional action other than checking a box for the employee to do this.
Right, and I think what it also does, Helene, is it also shows individuals at the company that misconduct is not going to be condoned, that everybody is empowered to bring it to the surface, and that they don't have places that they can hide, or that they can manipulate one person at HR and then the issues will never rise to the top. This empowers every employee to bring the issue to the surface.
Right, and what it also does is, and this is the litigator, I mean, you heard in my introduction that I'm a trial attorney, I'm a litigator. What it also does is, from the company's perspective, if you've got an employee who is now somewhere down the road claiming that they had been the victim of harassment for a period of time, but never used any of these mechanisms, never checked the box, never clicked on the SOS button, never called, never wrote, never did anything to communicate that, that's ammunition that the employer can use if there's potential litigation. Their defense is called avoidable consequences, which is the subject of yet another webinar we could do. But the bottom line is, it's just more mechanisms for the employee to be able to communicate with the employer, and for the employer to be able to address and acknowledge what's going on with the employee.
And it also it shows part and parcel of the process. It shows that if the company is taking its obligations to protect all employees seriously, that it's not paying lip service. It's not one document that's tucked in amongst many other documents, that it's a living, breathing procedure and process in place.
Right. So now that you know what the policies are and what policies you have to have, and there are complaint mechanisms, the next step is, okay, now what? You've got an employee who is either clicked on the SOS button, called through one of the 800 number or the global compliance, reached out to a manager, reached out to human resources, somehow communicated that there is an issue. Obviously, the next step is for everybody to take it seriously. And the first step in taking it seriously is to conduct a thorough investigation. So David, what are the basic steps that one needs to go through in order to figure out what actually went on? Because as we all know, just because somebody makes a complaint doesn't mean it's true, and doesn't mean it exactly happened the way the employee said it did. It could be better, could be worse. So how should an employer approach the whole process of conducting an investigation?
Exactly. Well, before I get into the actual nuts and bolts of the investigation process, I think we need to think about and answer the question, when is an investigation needed?
Well,
right?
Are there any times that somebody makes a complaint that it's not the obligation of an employer to investigate?
No, that's exactly it. Every time a complaint is raised, no matter how minor, obviously how major, or how redundant the complaint seems, you have to take every single complaint seriously. I can't tell you how many cases I've dealt with where one complaint is investigated, but others by the same employee are not. Serious allegations are investigated, less serious issues are not. An investigation is conducted initially, doesn't reveal anything. Later on, a complaint is made. It seems to be the same complaint. It seems to be the same issues. It's not investigated out of an assumption that there's no need, out of an assumption that you know the conclusion. That's a mistake. And more times than not, that comes back to haunt a company.
And I'll give you one minor war story about how that all comes out. Say you've got an employee who makes a complaint and you don't investigate because you say, you know what, that's just, she's making a complaint. Oh, that's just Joe being Joe. No, he doesn't mean anything by it. And the company just doesn't do anything about it. Then the next thing you know, somebody else is complaining. And then the third person's complaining. And now you've got no record of any of the other people complaining because you never investigated any of them. And then the fourth person who files actually is the one that files a lawsuit and says, you know what, had you investigated in the first instance, had you investigated when the first person made the complaint, none of this would have ever happened and I would have not been subjected to the inappropriate conduct. So conducting an investigation, regardless of what your impressions are, and it's very key that you don't form any impressions about what the outcome is going to be of the investigation until you actually conduct the investigation. But that's why it is vitally important that regardless of whether you think that the issue is big or small, whether it's against the lowest level in the organization or the highest apex in the individual in the organization, an investigation must be conducted. Right, David?
100%. We cannot overemphasize the importance of investigating every single complaint. So why do we investigate? What is the purpose of an investigation? In my opinion, the purpose is twofold. Number one, you obviously want to find out if any misconduct occurred. If it did, you want to make sure that you're aware of it. You want to make sure that you're aware of the entire scope of it, and you want to make sure that you put an end to it. Simultaneously, not every complaint that's raised is going to lead to a finding that actual harassment occurred or actual misconduct occurred. And so in those situations, and in all situations, a secondary purpose of the investigation is to document the entire process. Memories fade, recollections fade, employees leave a company for whatever reason, and these issues may snowball later on. They may disappear and you'll never hear about them again. If you never hear about them again, great. If an issue arises again 6 months later, a year later, 2 years later, the statute of limitations in a lot of claims can be up to 4 years. You could be dealing with issues that happened so long ago that nobody at the company that was there at the time or that was involved is still involved, is still employed by the company.
And even if you are, I mean, I don't know if anybody who's listening here or watching here, since it's a webinar, I don't know if any of you have ever had your deposition taken. You can answer this question to yourself. I know that I've had my deposition taken. And, you know, things just don't seem important when they're happening. And 2 years later or 3 years later, when your deposition is taken, you don't remember anything. Even if you were the person who conducted that investigation, it is very difficult to remember the minutiae and the details of the investigation because memories do fade over years. So whether it's the fact that somebody who's no longer with the company did the investigation and their notes are important, or even if it's you who conducted the investigation, you need to be able to have something to refresh your recollection. So now that we know the importance of documentation, because I mean, you know, document, and document some more has really been my motto. And I've done seminars that are like hours long, solely on the topic of the importance of documentation in employment settings. People don't get it, but it's just vital. So now that we've talked documentation, what is it that you have to document?
Right, and one more point on the documentation. I think the reason it's also important is the inherent nature of the workplace is such that there are so many conversations, so many moving parts, so many days where you're interacting together, so many facts, that reducing it all to writing, and reducing it all to writing in a way that documents all the various players' positions, that then helps the facts set into the cement a little bit more, be a little more fixed. So then later on, recollections can't change innocently or less innocently. So what do we do once you get the complaint in and it makes your way, it makes its way to the company? So at the outset, you need to determine, was this complaint made confidentially or anonymously, or do we know who the accuser is? If it's made anonymously, I don't think we would know who made it. We may be able to figure that out, but if it is made anonymously, I think what you need to start with are the facts of the complaint. who is being implicated, what is being implicated. If we do know who's making the complaint, then I think we start with that person. And so what we'd want to do is approach that person and conduct an interview. If there's concern about the individual changing their story later, or if it's a highly contentious situation, let's say you have an extremely poor performing employee that may have been less than honest in the past, you may want to have a witness on the interview with you. And that's two individuals that can attest to what's going on in the interview. The purpose of the interview is going to be to talk about the four corners of the complaint. You're going to want to figure out what facts were raised, but you're also going to want to get context, because context matters. And so while they may provide you with a specific statement that I was harassed or I don't like the way I was treated, you're going to want to find out the interaction that occurred between those individuals and figure out if there's anything more. And so going into the investigation, you're going to want to do that with a lot of open-ended questions and to get as much information as possible.
Now, David, where in this process do you actually ask, or do you recommend that our viewers ask the question, ask the person who's making the complaint to actually write out something in writing that they sign asserting what their claims are and what their allegations are? Is that something that you recommend be done as a step in the investigation process? So
I think you definitely want to keep it in mind as a potential option. I think every investigation needs to be examined on a case-by-case basis and on a allegation-by-allegation basis. If you have a lot of witnesses, that you think may leave the company, if you have individuals that you may think later on may change their story, then yes, you may want to have them, during the course of that interview, write out a statement. You should be mindful in terms of how you frame what it is that they're going to be writing about, and be mindful to allow them to put it in their own words. Their own words are going to be powerful in that they're choosing what words to use, they're choosing how to frame the issues, and then you can discuss those very same facts and statements with them later on if they have divergent recollections.
And again, this is the litigator in me coming out. It's not uncommon that what may happen is somebody might make a complaint and give you something in writing, setting forth every allegation that every incident that they claim happened. Then, so they've got that in writing and they've signed it. Then you interview them and they tell you something, but some things that were on the written list may be left out and other things might be added that aren't on the written list. So then you keep your notes as part of the documentation for your file. So you now have a file that has the notes in the writing of the victim and in your writing, and then you'll have all the rest of it. When it comes down to if this turns into litigation, if this turns into a lawsuit, you then have all these various accounts. They might be consistent, they might be inconsistent, and they can be used in various different ways from a strategy perspective if this actually does turn into litigation.
Exactly. And you'll want to repeat this process not only with the individual that's raising the complaint. I think that's where you start. They're the individual that brought it to the surface, but try to figure out what are all the facts that comprise the situation that's come to light. You may want to find out, has anything else occurred? And just putting it in those words, has anything else occurred? Has any other offensive conduct occurred? Please let me know. And if they say no, great. If they tell you, then you're aware and you can factor it into the overall analysis. If it's information that hasn't come to light for a while, you may also want to ask, why wasn't this previously brought to light? Why are you bringing this up now? Maybe after your third reprimand. For whatever reason, maybe I'm being a little cynical, but you do want to find out what happened and why they're bringing it to your attention. If it happened the day before and they're bringing it to your attention, I think it's fairly obvious, but still ask. So find out the facts, find out the witnesses, because individuals can then confirm, essentially corroborate, or dispel, or not corroborate the allegations. But witnesses also need to be determined as part of the process. And then the third prong during the investigation, you'll want to determine all relevant documents. And when I use the term documents, I mean it in the broadest sense possible. And so you'll want to tick off various categories during your investigation. Are you aware of any text messages? Do you have any photos? Very importantly, do you have any emails? Are you aware of any emails? I don't think it's an understatement to say that each of us sends dozens of emails a day or more, and that the email exchanges and any documents for that fact can then be pulled, reviewed, and then used to, again, corroborate or dispel the allegations that are being raised. Do the emails match up with the timeline that the person is putting forward? Do the contents of the emails match up with the characterization? And so on and so forth. And so, again, if we keep our goalposts in mind, we want to find out if there was any misconduct, and we want to make sure we're properly documenting, regardless of whether there was misconduct. Then that'll help steer us as we go down the road together.
And then you create a document. Then I assume that you then create a investigation summary report summarizing all of the results of everything that you've done, correct?
Definitely. And the way I think you would go about doing that, and I don't want to oversimplify the process as this entire situation, this entire presentation actually, depending on the severity of what's being raised, you may want to loop in an attorney early and often. But in general, when you're summarizing the investigation, you'll want to frame the issue. So such and such raised the complaints of such and such, or these issues have been raised in the workplace. You want to lay out what it is that you've done. So essentially who you've interviewed, the documents that you've reviewed, the facts that you've compiled. And so it sets the issue, it sets out what we've discovered, and then we can have an analysis in terms of factors pointing maybe towards bad behavior having happened, mitigating factors, and then reaching some type of conclusion. But before we get there, so to speak, I think you need to be mindful as you go through the investigation. Keep an open mind, get as many facts as you can, and to the extent that you go through the witness interviews and you go through the documents and you notice inconsistencies with the original allegations, you notice maybe additional bad acts or bad facts during the investigation, maybe you see that the accuser engaged in bad conduct, rather than rushing to judgment, which this whole process is designed to prevent, strongly consider, and oftentimes go back to the accuser and conduct a second interview, possibly a third interview. And so what you'll have is a process by which you funnel in the information from broadest down to narrowest, such that the facts as you understand them should hopefully at the end of the day be in keeping with what actually happened and with everybody else's understanding.
Right. So we just received a question, and I promise I'll answer this question in just a couple minutes, so hold on for just a couple minutes. So, and you know, the investigations are not easy. I mean, we just gave you a brief, like 10-minute summary of what we do programs, and we train people on how to do investigations, because they're not easy. We do seminars that are hours long, all about the proper way to do an investigation. It's not easy. But one of the things that you need to think about at the outset is, who is the right person to conduct this investigation? This is not a one-size-fits-all situation. Sometimes having an experienced and trained human resource professional conduct the investigation, sometimes that's wholly appropriate. Sometimes it needs to be a more senior human resources person. Sometimes some companies, depending upon the size of the organization, have actual internal investigation teams who their focus and their job is basically to conduct investigations. Sometimes it's important to get an outside investigator. This can be an outside lawyer. It can be, there are firms out there that usually are comprised of lawyers, but who do investigations. It really depends. What does it depend on? It depends upon everything from who it is that's making the complaint to who it is that they're making the complaint about, the seriousness of the allegations. All of those come into play when deciding who it is that should conduct the investigation. For example, if someone is making has a complaint that a coworker used some inappropriate language to them and they're offended by that, you know, that's probably something that a trained human resources investigator can do, or a trained human resources professional can conduct that investigation. What if it's basically somebody's complaining that their manager is asking for sexual favors or has cornered them someplace? Well, then it depends upon who's the employee and who's the manager. A lot of organizations, especially in this Me Too era, especially with the resurgence of hearing about all these complaints and hearing about all these high-profile individuals being accused, a lot of companies have gone to, if they've got anyone in any form of a senior position who's being accused of engaging in the inappropriate conduct, to hire an outside investigator. That outside investigator, whether they're a lawyer or an investigator with some kind of legal background and legal training. And the reason why, just as an aside, the reason why the legal background and training are so important when you're retaining somebody outside to do the investigation, this person is going to be witness number one in the event this turns into litigation. Their report is going to be Exhibit A in any litigation. So it's important that the person who's doing the investigation understands the ramifications of the investigation. So that's why I'm harping on using a lawyer, using an outside investigator who knows the law in some of these more dicey investigations. But why would you hire someone from the outside? Well, they're not beholden to anyone. There's always a fear, even if you get your most senior human resources person in your organization to conduct the investigation, there is always the fear that that person may be friends with the person they're investigating, may have some other connection to the person they're investigating, may report to the person they're investigating, may depend for their paycheck on the person they're investigating. And so retaining somebody who's an outside investigator, especially when you're dealing with claims made against someone who is senior level within your organization, is really the right thing to do. Not only does it ensure, I mean, you may have the utmost of trust in your human resources department. What it does is it doesn't only ensure against impropriety, but it also ensures against the appearance of impropriety. Because when it comes down to it, you want the employee who's made the complaint to realize how seriously you take this complaint, how seriously you're taking the investigation, and that you don't want there to be even a whiff that there might be some collusion, or there might be some belief that there's some hanky-panky, for lack of a better term, that the person who's being investigated is being really protected by the company. Having an outside investigator get involved and conduct the investigation, prepare the report. Ultimately, the decision as to what happens to that person is not made by the outside investigator. That's made by the organization. But at least having those investigations done by someone outside really is key to helping these situations. So now it comes down to, what do you do once you have these results?
And one point on who does the investigation, I think maybe employers should also be mindful and maybe consider an investigation as a living, breathing process. And so I think it would be ideal to make a decision if you need an outside investigator from the outset. But if you start finding yourselves getting in over your head, or the facts aren't as clear as you initially thought they were, or the allegations greatly expand, started off with one person, may have 40 people on your hands all raising the same issue, it's never too late to change tack and to rope in somebody from the outside.
Absolutely. I mean, if you're looking at a systemic claim, and if you're looking at a situation where you have one person who made one claim and that's leading to dozens more, then you really do need to consider getting an outside person, regardless of who the complaint is being made against. Similarly, sometimes companies look to get outside investigators retained if the allegations are too interesting. And when they say too interesting, they lead themselves to gossip, could just be too interesting allegations. If you even have a thought that it might be too interesting to look into, get an outside investigator involved. So, and now we're going to get to the question. And we actually have a couple questions, so I'll get to the first question. So one of the questions that was raised was, what happens if you have two employees in a consensual relationship that goes south and both are accusing each other of harassment? Well, that comes to the next topic, which is, what do you do when you get to the results? You now have an investigation. You've had a complaint made. So in this example, 2 complaints made about each other. And say you've reached your conclusion. The conclusion is that you guys had a consensual relationship once upon a time. You now are accusing each other. There's been an investigation conducted that proves all of that. Now what? You know, I will never forget, it wasn't that long ago, so of course I won't forget it. But in the course of this whole Me Too movement, I remember waking up one morning and driving to work, and I heard a news story, and it was the day that all the news about Matt Lauer broke. And in the same breath, you heard the news commentators say, oh yes, Matt Lauer was just accused of sexual harassment, and oh, by the way, he's been fired. Which leads everyone to believe, what happened? In the same news story, we're hearing both about the conduct and about the result. Well, clearly there needed to be some investigation, and I think what we learned in subsequent days and weeks after that was that there was investigation. This wasn't the first time. But what do you do when you've got proof that, and their investigation reveals that there was sexual harassment? Well, not one result fits all. And this is another one of those circumstances where some things might be pretty obvious. If you have an accusation that a manager pulled a subordinate into a dark closet and tried to rape her, and it's established that really happened, well, there really looks like there's only one resolution to that, and that would be the person should get fired. But not everything is that extreme. What about water cooler talk? I mean, I remember years ago, there was a lawsuit that was actually filed. I don't know how many of you actually ever watched the show Seinfeld. It was a television show shown on primetime TV, so even your children could watch Seinfeld. And there was an episode of Seinfeld where Jerry was talking to the gang about a date he had the night before, and the name of his date, her name rhymed with a part of the female anatomy. I don't know if you ever saw the episode. It was actually kind of a funny episode. But there were two people that went to work one day and were standing by the water cooler and just having a conversation about what they saw on primetime TV the night before. And there was somebody else standing who wasn't involved in the conversation, but who overheard this and who was offended by this talk and the language that was used. Is that the same kind of inappropriate conduct as the manager taking the subordinate into the locked closet, into the dark closet? I don't think anyone would agree that it's the same kind of conduct. You know, the answer to how to respond when you have a determination based either upon an investigator's report or an internal investigation report, the way to respond to what do we do next is, it depends. Every case has to be evaluated differently and separately. As to the issue about consensual relationships in the workplace, there's actually a term, and don't laugh because you may have heard it before, there's a term called a love contract. And I mean, a lot of companies, especially now, are trying to implement non-fraternization policies. At a minimum, they're trying to implement policies that say that if you are in a reporting relationship, meaning one person reports to another, the two of you cannot be involved in any kind of a romantic relationship. That makes sense. I mean, you know, we do meet people that we work with, and a large percentage of the people that meet at the workplace and end up dating in the workplace ultimately get married and live happily ever after. Sometimes it's not so easy, and sometimes it doesn't work out quite as nice and neat as that does. But there are things called love contracts that we will often have clients ask us about, which is basically an agreement between these two people that they each sign. They say, yes, we recognize we're in a consensual relationship. Neither one of us reports to each other. We promise to let the company know at which point if the relationship goes south, and what happens if away from the office stays away from the office. I mean, the best workplace romances are ones that nobody knows about, are ones that everything that is said and happens between the two of them happens away from the workplace. But if it goes south, and if one starts complaining about the other, you need to address it with them the way you would address any other complaint. Because at some point in time, something changed, that this consensual relationship is no longer consensual. So preferably, you would have the love contract in place and have the employees advising you when the relationship is over with, so you know at which point the conduct, which may have been consensual one day, is no longer consensual.
And I think on that point, it's important to have a policy at the outset in your handbook, which provides that it's either allowed or not allowed, romances in the workplace. And either way, let's say it is allowed, that they need to disclose it to the company. So there you've set a rule in the workplace that they need to disclose it to us as it's happening, and then we're aware of it. Then we know what to do about it. then we can actually take this step that Helene is recommending.
Exactly, and so that if the complaint is raised, you at least then will be able to know when it is that the consensual relationship turned non-consensual, and people need to realize that it's not accepted anymore. If that doesn't answer your question, ping in with another question and we will get to it. Okay, so there's another question that came in about the topic that we just discussed, which is what are some of the downsides to setting up an anonymous complaint hotline? You know, anonymity only goes so far. I mean, and what's good about an anonymous hotline is it makes people feel like they can go to some anonymous source out there. They're not complaining to their manager. They're not complaining to the alleged harasser. They're not complaining to human resources. They're complaining somehow outside, and that makes them feel better about the complaint. Fortunately or unfortunately, you can only allow anonymity to certain extents. The person who the complaint is being made against is at some point in time entitled to know what the complaint is that's being made against them. So to that extent, and to the extent that it requires advising who it is that made the complaint, as far as to the person who the complaint is being made against. I mean, in my example of the manager bringing somebody into the dark room, I would hope that that would only have happened once, so that the person who made the complaint, even if they made the complaint anonymously, when the manager is told, hopefully he will know exactly who it is, and hopefully it's not going to become a bigger issue, and they think that, well, how many people have you taken into the dark closet? But regardless, anonymity only goes so far. So people need to be told that anonymity will, that their identity will be remain anonymous only on a need-to-know basis, but there are certain people that will need to know, including the person against whom the complaint is made, because they are entitled to be able to respond, because allegations are just allegations until they're proven to be true.
And I think it's also important to make clear that to the extent that you allow complaints to be made anonymously, such that you're not disclosing your name, maybe you're fearful of retaliation, maybe you don't want to get involved in the process and you just want to alert the company, I think it's important to make clear, to the extent that you permit anonymous complaints, which you may consider doing, that there are limits to the investigation that can ensue. Meaning, if I don't have enough complaints, if I don't have enough facts in the complaint, I don't know who to go back to interview to find out more facts. I don't know who is the credibility of the individual making the allegations. And so folks, while they can have the option of making an anonymous complaint, they should be aware it does have limits. And so oftentimes it may behoove them, and it may behoove the organization and their colleagues to actually disclose who they are.
Yeah, and one of the things that we often see for anonymous complaints, we'll often see something like a whole list of individuals to interview. They might not identify who it is that is making the complaint, but they might identify a whole list of individuals to interview. This could lead to an entirely different type of investigation. We'll call it an environmental survey. It may not be a specific isolated, he touched me inappropriately, he made an inappropriate remark, she was trying to, she cut my hours, whatever it is. It might not be something like that. It might be an environment of harassment. Those can lead to what's called an environmental survey. And if you get a complaint about that, whether it's through an anonymous hotline or otherwise, but those often come in through anonymous hotlines, it's something that requires a different type of an investigation of your workplace. An investigation that really is more attuned to finding out and doing a broader investigation, possibly interviewing everybody in the workplace, everyone in the department or in the environment, to help figure out if this is an environmental, systemic type issue, as opposed to a simply she said, he said, he said, she said, he said, he said, whatever situation. You know, there are lots of things that can be done to prevent harassment in the workplace. I mean, we've been talking about, I mean, unfortunately, you can never stop people from being people. If somebody wants to do something and wants to say something, you can't stop them volitionally from doing it. But culture-wise, and this is addressing one of the other questions we received, culture-wise, the things that we've been talking about to this point really do help. Making sure that everyone is aware how seriously you take harassment in the workplace, how seriously you take people's right to work in a professional environment, how seriously you take their ability to work in a harassment-free environment is key. And that comes from the top side and up from the bottom. It comes from having policies. We've been talking about all the policies that you have to have in place. And it comes from promulgating those policies, making sure people know about them, posting them. It comes from having all of the complaint mechanisms in place, letting people know how to complain, who to complain to. And a big part of where it comes from training. And that's actually the next thing we want to talk about is how to conduct training. I mean, training is something that we've been doing in California for years. It's been required by law. Certain training is required by law. Certain training is simply good practices. I mean, I will tell you that I've been recommending to my clients to do sexual harassment training since long before it became law in California. California and several other states require it by law. And even when it's not required by law, it's a good practice. So David, why don't you talk a little bit about putting a training procedure in place, and a training mechanism?
No, I think that dovetails perfectly into this topic, because I think you can have the best drafted policies in place. Could have taken a lot of time to put them together. I think you can have great procedures in place, but I think if nobody's aware of the policies, and if nobody's aware of the procedures, and nobody is aware of the importance that the company places on these policies and procedures, then people are not going to use them.
And they're not worth the paper they're printed on if people don't know that they're there.
Exactly. And so the culture at a company is set from the top down, but it's not a one-time issue that is set up and is in place forever. So when do you do training? How do you do training? How do you make sure that everybody is fully aware of how the company operates from a policy perspective and the type of conduct it does not condone? And then how to go through the entire process so that you feel comfortable being a participant. I think that by having adequate training in place, that sets the employees' minds at ease, and it also puts everybody on a common ground and provides everybody a common goal that they're working towards. It's to have a great workplace. It's to make sure that there aren't any folks misbehaving, so to speak. I think that by also making sure that there's proper training, it also makes people realize that I can't just raise offhand comments, I can't raise frivolous complaints either. And so over time, you'll see the culture at the company improve. So when do we do training? And who gets the training and who gives the training? So I'd say at the very outset of this process, at the bare minimum for incoming employees, they should, at the time of hire, get the employee handbook. They should get any other material company policies and procedures explained to them. And so not only should they get the handbook itself and given an opportunity to review it, and they should actually be asked to review it, and then maybe a couple days later, a week later, then hold a new employee orientation meeting. And you can explain the policies, you can explain the procedures, and you don't have to focus just on the harassment, obviously, but you're definitely going to want to focus on that as one of the topics in that training. Now, when you give them the employee handbook, a week later when you do the orientation, try not to do the orientation maybe on the spot. They're not going to have a chance to read the whole handbook then. They're not going to be able to come to you with questions. If you do the orientation up front, circle back, ask if they have questions. A couple days after you've given them the handbook or longer, get an acknowledgement. Usually that's the last page. It indicates a receipt, it acknowledges that they've read it, and it acknowledges that they have the opportunity to come to the company to ask questions about it. Well, I think that's a great start. I don't think that's where you end, in that you may want to then revisit the training with the lower level employees periodically. You may consider, if you revise your handbook annually, then you're going to want to hand out the handbook annually. Even if you don't revise it, let's say you look at it, everything looks good, you may still want to hand it out again. I mean, the relatively nominal cost of doing that versus the knowledge and awareness and the tone that you're setting, I think it pays off dividends, because to the extent that folks can be aware of the ground rules up front, that may prevent complaints and investigations later. To the extent they're aware of the procedures, that can prevent litigation later. So make sure that everybody is aware. But then who does the training and who is trained? You want to make sure, obviously, and what we see, I think, oftentimes is upper management that's very well trained. HR, I'd say very well trained. There are times, I think, when you operate in multiple states that you need to have a sensitivity to states in which HR is not located in, that those procedural or legal requirements may be different, so be mindful of that. And upper management HR, consider having them receive training from lawyers, consider them having them receive training from outside professionals. And as Helene alluded to, in California, for example, managers have to receive sexual harassment training. So some of these are just outright requirements, but even if not, by making sure folks are properly trained, that's going to save you a lot of headache on the back end. I think in addition to that, at a bare minimum, have folks trained in a way where even if they can't answer all questions, they should be able to spot the issue. And that's particularly important with the low-level managers, the folks that are the front line, because they're going to deal with a lot of issues, and you want them to escalate them appropriately.
Right. Yeah, that's very important. People need to realize that they are not the person to do the investigation. That's why you have HR, and that's why you hire outside investigators. The bottom line to all of this, and training, there's no right or wrong way to do training. Training can be live, training can be via webinar, as long as the training allows individuals the opportunity to ask questions and answer questions and make sure that everyone knows what is and is not accepted in the workplace. That is really what the key is. We received another question about the process and procedures for closing an investigation and resolution of the complaint. Excellent question. Because I can't tell you how many times I've had a situation where a client calls me and says, okay, we investigated, and then my response is, yeah, and what conclusions did you reach? Oh, we were supposed to reach conclusions? Well, then why is it that you did the investigation? It wasn't simply fact gathering. Fact gathering is a big part of it, but then you have to do something with that information, including closing out the investigation. And that means, as I was talking about earlier, after you do the investigation, as David discussed it, you have to reach a conclusion. What happens? Is this person supposed to be fired? Should they be fired? Should they be disciplined? So you have to make a decision in terms of what to do with the person accused, if anything, based upon the results of the investigation. You also should circle back and conclude things with the person making the complaint. That's vital. The reason why you do that is so the person realizes that you did something. You may have talked to that person initially, gotten their story, did the investigation, gone on your very merry way, and then maybe even taken action against somebody and not communicated back with the individual who made the complaint. Now that person, if the person who they complained about is fired, well, they're probably going to know the result of the investigation. If the person isn't fired, keep in mind the person who's being accused has rights too. So the person who made the complaint isn't entitled to necessarily know what disciplinary action, if any, was taken against the individual who they complained about. What they are entitled to know, and they should know, is that an investigation was conducted, you met with people, you investigated, you spoke with people, and that appropriate action has been taken. And if it happens again, or if anything else happens, that person should be given a direct pipeline to whomever it is in your human resources department to complain again. That's a way of closing out, but it's very important to let the person who made the complaint know that you actually took action and that something did happen. Because otherwise, I can't tell you how many times we see in complaints, the person filed a lawsuit because they believe that nothing happened because, well, the person they complained about is still there. They don't know that anything happened. And I hope that answered the question. And I just got a text message that we've only got a couple minutes left. We want to thank you very much for your attention and for your questions.
Yes, thank you.
We don't know if you have any other questions that you weren't able to ask in the time that we have had here, but we hope that this is helping you navigate a little bit more through how to protect your employees and your organization in this Me Too era. If you have any other questions you'd like to get answered, please reach out to either me or to David. I'm Helene Wasserman. We're David Mouse. We're both with Littler. Please feel free to look us up. reach out to us. And again, thank you very much for your attention and for your very thoughtful questions.
Thank you.
Thank you, David and Helene, and thank you everyone for attending. If you wish to have this session count for CPE credit, please email info@pmbaonline.org with your request if you have not already done so. Later this week, this webinar will be posted on the members-only portion of the website. Thank you again, and have a nice day.
Thank you.